Welcome once again to Lehto's Law. Here's Steve Lehto.
Had a couple people send me a story out of Kansas involving an attorney who's been kicked out of the bar in Kansas for misconduct while as a prosecutor. We talked about some of these aspects before, but it's all wrapped up in one case here, so we'll talk about this. Brad and Neil both sent it. Stories in the KansasReflector.com. Kansas Supreme Court disbars former Shawnee County prosecutor for unethical conduct. Violations of professional ethics and Chandler murder trial are the focus of the disciplinary case. So they actually said, we're going to look at just one case. But there were allegations of problems in more than one case and how she handled them. Tim Carpenter wrote the story. The Kansas Supreme Court issued a 101-page opinion on the discipline for this former attorney, and they've disbarred former Shawnee County prosecutor for a pattern of unethical conduct resulting in significant prejudice against the accused. It's the most stringent punishment available to the Supreme Court and followed the unanimous recommendation of a 3-attorney panel that heard evidence of this person's penchant for making false statements in court. The justices found that she'd violated more than a half a dozen Kansas rules of professional conduct. There are rules attorneys have to follow, and every state's got them. And if you don't follow them, you can get in trouble. The evidence in this case demonstrates a serious pattern of grossly unethical conduct, the Supreme Court wrote. After carefully considering the findings, conclusions, recommendations, and the American Bar Association standards for imposing lawyer sanctions, we find that respondents' intolerable acts of deception warrant the severe sanction of disbarment. Now, it's interesting they cite the American Bar Association standards because the ABA actually has no jurisdiction over attorneys in America. And a lot of people think it does. And I've had people say, well, Steve, you're a member of the ABA. So no, I'm not. I'm not a member of the ABA. I used to be because I used to get their high-gloss magazine once a month. And eventually I stopped reading the magazine and I stopped being a member of the ABA. I'm a member of the Michigan Bar. And as long as I'm a member of the Michigan Bar in good standing, I can practice law in Michigan. So why they consulted the ABA, I'm not sure, unless they're simply trying to show that there's so many rules out there that she was in trouble with that we find that our actions are warranted here. In addition, the court mandated the Office of Judicial Administration strike her name from the roll of attorney's license to practice law in Kansas. Her disbarment coincides with the publication of the decision. It takes place immediately. She came under scrutiny after winning convictions against one person in a double homicide case, and later for her work on a Jackson County sex assault case. In both instances, the convictions were overturned on appeal. Kansas Board for Discipline of Attorneys, panel of lawyers, recommended disbarment of her after concluding she knowingly and intentionally engaged in deliberate misconduct to win convictions. In a highly unusual maneuver, the state's disciplinary administrator independently urged the Supreme Court to reject the hearing panel's conclusion and impose a lesser punishment of indefinite suspension. However, the court ignored that. She asserted she couldn't receive any form of discipline for what the Supreme Court concluded was a pattern of serious misconduct and dishonesty, warranting disbarment. Her attorney said during the disciplinary proceeding that she made mistakes during the trial that they're talking about here, but she didn't intentionally try to mislead jurors. And mistakes and lack of intention, if true, might dial it down a little bit, but as a prosecutor, you shouldn't be making mistakes of that magnitude. The Supreme Court majority concentrated on prosecutorial misconduct in the Chandler trial and decided to set aside the issues raised in the other one. It didn't need them. The justices concluding that she had ignored orders of a district court, repeatedly made arguments to the jury that lacked evidentiary support, and intentionally lied to the Supreme Court in her written briefs and during oral arguments, and made false statements during the disciplinary investigations. So they're saying not only did she commit misconduct in this one trial at issue, but she committed misconduct in dealing with us on the issue of the misconduct in the other trial. And of course, they say intentionally lied. And I've got to point this out because that's actually redundant in many respects. If you intentionally lied, well, if you lied, you did it intentionally. because a false statement is not necessarily a lie, right? So if I mistakenly believe something to be true and I tell you that it's true based on my belief, it's not a lie, but they say intentionally lied because they want to remove the argument where she could say, well, that was a mistake. No, we found that you did it intentionally. And it's a lie. It's an intentional lie. But like I said, it's kind of overkill. But they say that she did those things during this case. The other question I have is if she made these mistakes during a trial, mistakes that she calls them, that she didn't intentionally, try to mislead jurors. The question is, did anybody object? Because they claim that she made arguments not based on facts. And that's something your opponent should spot. A defense attorney should notice, excuse me, Your Honor, objection. There's no evidence of that in the case. In a dissent, a former chief judge of the Shawnee County District Court said the majority accepted the hearing panel's recommendations to strip her of her profession, despite a brief saying that she was one of the most skilled, successful, and expert trial attorneys in the state. Well, you know something? When you point out that somebody's one of the most skilled, successful, and expert trial attorneys, and they get convictions by cheating, you got to wonder how useful that statement is. Seriously. I mean, when you're talking about how this person's so good, we should take a second look at this. Well, is one of the reasons we think they're good because they kept winning? The judge who's dissenting here said the other justices discarded for lack of sufficient evidence a portion of the three-lawyer hearing panel's most serious findings. Oh, she did make mistakes, and those mistakes were serious and costly. They caused reversals of convictions for murder and rape, but we also know some of her mistakes were based in part on mistakes made by other professionals who are honest and highly skilled. And we're not quite sure what they're getting at there unless she's simply saying, well, her defense attorney that she's facing in those cases, those attorneys should have objected, I guess. I don't know. In 2021, she resigned from legal positions in 2 counties and placed her law license on inactive status. And that's actually available to most attorneys if you want to. You can take your law license and make it inactive. You might say, Steve, why would you do that? 2 reasons. One is you can save money. I know attorneys who retire and don't plan on practicing law, but they want to keep their law license just in case they change their mind later, and you can reactivate it. But here she appears to have done it in the hopes of saying, look, I've already kind of punished myself. I took myself out of the running here. I placed my law license on inactive status. She earned her law license in 1992 and secured roughly 80 murder convictions during her career. She landed before the disciplinary board of the Supreme Court a while back, and it was the Supreme Court, apparently, that overturned the 2012 double homicide conviction that is at the center of this case, and the Kansas Court of Appeals overturned the 2017 guilty verdict in the other case. She was lead prosecutor in both cases, and yes, right now we're talking about the case that got her in trouble happened 10 years ago. But the stuff apparently didn't come fully to light until that case had wound its way through the appellate system. So I'm not sure how long it takes a case to get to the Kansas Supreme Court, but it must take a few years. Meanwhile, one of those defendants who got their conviction spun around accepted a plea deal to avoid another trial, while one of them is awaiting retrial on the original charges. I'm glad that the Supreme Court disbarred her for the misconduct she committed in the 2012 Chandler case, the attorney said, who is helping one of those defendants. I'm disappointed that the court didn't go farther and fashion a remedy that would address the serious injury her misconduct did to the administration of justice. He also said he's disappointed that one of the judges considered disbarment too harsh a sentence, given evidence of the abuse of prosecutorial authority. In 2018, the state Supreme Court unanimously found justification to reverse the conviction for the double homicide. In a decision, it said the prosecution of the defendant by this attorney unfortunately illustrates how a desire to win can eclipse the state's responsibility to safeguard the fundamental constitutional right to a fair trial owed to any defendant facing criminal prosecution in a Kansas courtroom. In that opinion, a justice concluded, the state's obligation is to ensure its case is tried vigorously, but properly, championed to bring about a just conviction, not merely a win. Prosecutors are the state's instrument in fulfilling this duty. When they fail, our system fails, and the safeguards protecting the constitutional right to a fair trial strain to the breaking point. That is what happened in this case. So the whole point is that too many attorneys view court as a game that is to be won. So we're going into court on a trial, on a case, on a lawsuit, whatever it might be, criminal case, civil case, you name it. And they want to win. They want to win. And they will do everything they can to win. But there are rules governing what you can and cannot do. So you do everything you can within the rules, which is how you do this ethically. And if you step outside the rules, then you're cheating. And some people view gamesmanship, look at NASCAR. It doesn't matter if you're cheating as long as you don't get caught. And if you get caught, you just take the punishment. Well, cheating in NASCAR is one thing, but cheating in a trial is another. Because there, if you don't get caught, someone goes to prison that shouldn't have, that's very, very wrong. So this attorney, prosecutor, for one case, and what she did in the one case, the Supreme Court of Kansas looked at it and said, based on her performance and behavior in this single case, we are going to disbar her, take away her law license. Now, the one thing I don't see addressed here is whether she can ever apply to get it back. And they'll often say that, or they'll often leave it open, meaning that a couple years down the road, she might be able to reapply for admission. And then they would look at what she was disbarred for and ask, how do we know you're not going to do it again? So that's an interesting issue. Also, I'd like to point out she became an attorney in 1992. I became an attorney in 1991. So she's been an attorney almost as long as I've been. I've been an attorney for 31 years, as I often say. She was an attorney for 30. Big difference is she's no longer an attorney. So it's an interesting story, but it does show you that once in a while, they do enforce these rules. Sad part is that some guy was convicted of murder 10 years ago, and the prosecutor made arguments to the jury that weren't based on facts and evidence, and somehow that didn't get stopped at the time. Apparently, there's so many issues with ethical lapses on the part of the prosecutor that not only does that guy get a new trial, but the prosecutor lost her law license in the process. So that's a severe ending to this story for her. So, great case. Thanks, Brad. Thanks, Neil. Kansas Supreme Court disbars former Shawnee County prosecutor for unethical conduct. Tim Carpenter wrote that for kansasreflector.com. Questions, comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. If music be the food of love, play on.